So how do you bring a malpractice case in the state of Indiana? Hi, I'm Guy DiMartino. I am a Northwest Indiana medical malpractice lawyer, and I'm going to give you the skinny on how you bring a medical malpractice case in the state of Indiana. Medical malpractice is a different beast. It's a different animal than a regular personal injury case. So if I want to bring a personal injury case against somebody, I can make a claim with the insurance company. If that doesn't work out, or if I want to, I can go ahead and file in court immediately. That's not the case with a medical malpractice. If you believe that you have medical malpractice, most doctors are qualified under the Medical Malpractice Act. So that requires you to first undergo an administrative process. And the way the administrative process gets started is you go ahead and file a proposed complaint with the Indiana Department of Insurance. You say, I went to Dr. So-and-so, this was the result, the doctor was negligent, and because of the negligence, I have injuries. And that is the essence of the proposed complaint. At that point in time, if the doctor is qualified, the Indiana Department of Insurance will send a copy of the proposed complaint to the doctor and their insurance company, and then their insurance company will hire a lawyer that will represent the doctor in the Department of Insurance proceeding. Once a lawyer gets involved, the parties will go ahead and exchange information or discovery, and the parties will also go ahead and pick a medical review panel. This process could take months, it could take years, depending upon the facts of the case. The medical review panel will consist of 3 healthcare providers. Depending upon the type of doctor or type of healthcare provider the defendant or defendants are, that'll help determine the makeup of the medical review panel. Also, if there is an issue regarding the outcome of the medical care, you might need a doctor in a different specialty that can talk to the issue of what we call causation. The question of whether the negligence, if there was negligence, if there was malpractice, whether that actually caused the injury complained of, or as in the medical malpractice speak before the Department of Insurance, the resultant injuries or resultant damages. So that's how a medical malpractice case is started in Indiana. You file a proposed complaint with the Department of Insurance within 2 years of the date of the occurrence. Lawyers get involved, you exchange information, you get a medical review panel appointed, and then you provide your evidence to the medical review panel, and then the medical review panel will enter a decision on whether they think the doctor deviated from the applicable standard of care, or whether the hospital committed malpractice, and whether the malpractice resulted in your injuries. You have to do that before you go to court. Most people lose at the medical malpractice panel stage. You can still go into court, but you're going to have to go ahead and jump through a number of hoops. Otherwise, your court case will be dismissed. But that's a topic for another video. If you have any questions regarding Indiana medical malpractice, you can always reach out to me. I am Guy DiMartino, meeting you at the intersection of law and medicine. Have a great day.